And the prosecutor's argument telling the jury that Hailey Owens' mother wanted death was he knew was objectively false. There was a motion hearing.
Well, that wasn't what the argument was, though. I mean, that wasn't what he said. He didn't say that her mother wanted death. I mean, this was an argument that was brought up in the direct appeal, and it seems to me that this court's opinion in the direct appeal is somewhat similar to the trial court's judgment that this argument was a send the message type argument, not that that the family wanted or didn't want death as a punishment.
I know the direct appeal opinion said that this was not explicitly argued, but as I think the dissent pointed out, it could only be understood as a comment that the family members wanted death from Mr. Wood.
The trial court didn't see it that way.
No, and I think the trial court,
post-conviction motion, though, did it?
I think the trial court erred in not sustaining the objection and allowing that argument to be made. In fact, this is like the Taylor case where a prosecutor injects high emotion. In Taylor, the jury was told to get mad, be angry. And here, the jury was told, vote for death because this is what Hailey Owens' mother wants. That, while it wasn't explicitly said, that was the clear gist of the argument, and that's what the dissenting opinion pointed out, and I think did that very well. And I understand what the majority opinion said as well, but I think it was made very clear that that was what was being argued, that Hailey Owens' family wanted death. The problem with the prosecutor's argument is defense counsel had filed a motion to present what Hailey Owens' mother wanted, which was she did not want death. She wanted a life without parole plea deal. And she testified that if called, that's what she would say to the jury. It is really critical here in terms of the jury hearing that her mother wanted death when you juxtapose that with the jury did not get to hear. In fact, the jury could not get to hear what her mother wanted, but the jury heard all about what the community felt about this and falsely heard that her mother wanted death. So the jury never got to hear what, in fact, Hailey Owens' mother wanted, but they got this different perspective that, in fact, she wanted death, and heard all about this community impact as well. When you look at the closing argument and the objection that was made, counsel objected in terms of saying with the verdict, the closing argument was with your verdict, sentencing him to the ultimate punishment, you speak for Hailey. You speak for Hailey. Then there's an objection. You speak for her family. There's no other way than to construe that as you should vote for death because this is what Hailey Owens' family want. With your verdict sentencing him to the ultimate punishment, you speak for Hailey. There's an objection. You speak for her family. That's expressly what is being stated here.
There is, in fact, a different way to look at that argument, and I think it's the way that the trial court looked at it and the way that this court looked at it on direct appeal, and that is that what the prosecutor was arguing was that the death penalty was an appropriate remedy for the trauma that was caused to the family, and that would be based on the evidence that was presented at the sentencing hearing by members of the family, including the great-grandmother and two of the aunts who talked about the trauma that they experienced due to the loss of this child. So this is not a case of a clear-cut misstatement of fact, if it was a misstatement of fact at all. This isn't saying that X doesn't exist when in fact it does exist. This is a case where different interpretations can be drawn from a particular argument, as happened in this case. So it does not rise to the level of prosecutorial misconduct, and certainly does not rise to the level of a rare and exceptional circumstance that would warrant ignoring this court's guidelines for when claims are not cognizable because they could have been raised on direct appeal, and in this case were raised on direct appeal, and not cognizable because it was decided on direct appeal, and we don't get another crack at litigating the same arguments in a post-conviction case. And I think another point that needs to be made when we start talking about the wishes of the family, because As I recall, some of the pleadings that I've seen throughout the course of this case have made the assertion that the family wanted a life sentence. In fact, we only know the wishes of one member of the family, that being the mother. We don't know what anybody else in the family wanted. So it may well be that she was alone in her feelings, but be that as it may, it doesn't ultimately matter because the prosecutor at no point ever explicitly said any member of the family wanted a particular punishment, and certainly never said that any particular member of the family wanted to impose death, did not tell the jury that they should impose death because that's what the family wants. It was arguing the impact on the family, the impact on the community, and it was a proper argument as this court found on direct appeal. And I don't know that I would really have a lot more to add to that unless the court had questions on that or on any of the other points that have been raised in the briefs.